Defendant's present, represented by counsel, and we're ready to go ahead and move forward with the charge conference. I understand everybody received a draft probably about 7:30 last night. Realize it was a little bit into the evening. Hopefully everyone got a chance to take a look at it. I mentioned yesterday to counsel when we were working through how to approach this, what I have done. Well, before I do that, let me just go around. Anything from the state before we start?
No, Your Honor.
From Travis McMichael?
We're ready to begin.
From Greg McMichael?
We're ready, except I have one thing printing, if you would allow me to grab it. The printer was a little louder.
I'll get it.
And from Mr. Bryant?
Thank you.
We're ready, Your Honor.
I just got so excited to get into the charge, I forgot to go around. Sure. All right, got everybody back. All right, so I mentioned to counsel that what I have done to this point is I have the request to charge submitted by the state. I've got Mr. Bryan's first request to charge. There's an additional request to charge from Mr. Bryan, and the defendant's first request to charge, McMichael defendants, I should say. What we did is I took those requests and put them all together in one large document just to see where there was duplication on the charges. And then based on that draft, I narrowed down into the draft you received last night, what I'm calling draft number 2, which is really just a clean copy. I've taken, in places where, say, there were 3 different requests on the same issue, I have put in the draft charge you received last night what I distilled down into an appropriate, or what the court believes is an appropriate charge. I realize that this does not include all of the charges that have been requested. This obviously is everybody's opportunity to raise whatever issues you have with respect to the charge the court has picked. And we'll go ahead and discuss those on the record. In the draft you received last night, there's also some, I'm not sure how it came through as highlighting or gray, but there, you'll see there's some highlighting in that, in there. Most of that is the headings that will point to the issue of law addressed in the charge. There's also some highlighting in places where I just need to go ahead and clean up the charge, and we just hadn't had excuse me, an opportunity to do that before sending it out last night. So my plan is to go ahead and get through those drafts that the court, or the editing issues the court has at this charge conference also. Generally with the charge, the court will put a draft together, includes the headings just so everybody knows what's there. I give the jury a copy of the charge, but it does not have the headings in it. It's just basically the charge as read. I don't read the headings to the panel, just so everybody understands. Those headings are simply there for directory purposes more than anything as we go through the charge in the charge conference. Everybody understand where we are? My thought is the best way, and this may not work, we'll see. The best way to go ahead and get through this charge is I'm going to go through what I've got and make some of these edits that I know I need to make. and then I'll go back through and go around the room for exceptions or objections to the charge. Everybody understand what we're going to try to do, or how we're going to try to do it?
Yes, Judge.
Okay. All right, so what I'm going to do is just start on page 1. I'm going to start going through, and anywhere it looks like I need to make an edit, we'll go ahead and make that on the record so everybody's clear what that edit is. So on page 1 of the draft charge, there's the prefatory language, and then I've got indictment and accusation. On page 2, issue and plea of not guilty, presumption of innocence, burden of proof, and reasonable doubt. Page 3, grave suspicion, and then evidence generally. And
Your Honor, it's just to make sure I'm understanding our format, excuse me. If you want us to note anything at this point as you go through, just if we're reserving exceptions.
no, what I'm doing is I'm just going through right now. I'm going to give each party the opportunity, once we're done, so everybody knows where I am with the charge, to go ahead and make their own objections or exceptions.
Very good,
Okay.
thank you.
Page 4, stipulations. The court has some editing there. The main thing that I've got is I read them a stipulation charge, which is the stipulation charge I usually use. Since I drafted that stipulation charge, it looks like a pattern charge has come out, and this is the pattern. I'm inclined to go ahead and charge them on stipulation the same way I charged them during the trial. I'm going to go ahead and note that. So that language that's in or on page 4 is going to change a little bit, and we're going to use the court's existing stipulation that's already been used. Continuing on, page 4, direct and circumstantial evidence. Page 5, expert witnesses. Page 5 also, and I want to explain the court's charge. There is, on page 5, a credibility charge. The pattern charge, I think, comes now in 3 or 4 different parts on credibility. And when the new charge came out, there was an effort, at least in the circuit that I generally preside in, to try to consolidate those 4 separate charges into one that flowed better and put credibility in one more compact and I think more easily discernible charge. And so you'll see in that credibility of witness charge, all of the ideas from the 3 or 4 various credibility charges that are out in the pattern have been consolidated into one. And I'm happy to address any questions on that when we get to the objections or exceptions. But that's page 5. Page 6 is prior statements, single witness corroboration, and accomplice. Page 7 continues with the accomplice, and I've got some questions about that I'd like to hear from counsel on. Page 8 is coerced unknowing participant, not accomplice. We continue on to defendant's choice not to testify. Page 9, statement of defendant. Let's see, I've got an edit here. Yeah. And the way I'm going to read that is, before you may consider any of these as evidence, because we're talking about a number of different statements from a number of different defendants, you must determine whether the statement was voluntary. So I'm referring generally to statements and then specifically at the end indicating that each individual statement needs to be addressed. So I've dropped off the statement was voluntary. We continue with voluntariness defined, burden of proof as to voluntariness, corroboration. 10 is the Bruton charge that we've already, I believe, we have already charged the same language. Then there's limiting instructions. I do have a question about that. I'm not going to get into the edits until I hear from everybody on the limiting instruction. Prior difficulties also I have some questions about, so I'm going to wait on edits there. Identification is on page 10. Page 11, identification, burden of proof. And then fingerprints. Page 12, definition of a crime and intent. Page 13, no presumption of criminal intent, parties to a crime, principal failure to prosecute, and knowledge. Page 14, just an edit I need to do, let's see. And that would be that a crime was being committed. That's the edit there. So that's knowledge on 14. I've just made the edit. It's first paragraph reads, on the other hand, should you find beyond a reasonable doubt that a defendant had knowledge that a crime was being committed. Continuing on, we got conspiracy. In conspiracy, additional instructions, conduct and presence of parties, venue. Page 15, offenses charged, malice, murder. Page 16, motive, felony murder, causation. And I do need to add in, I'll hear from the parties on what exactly, if anything, we should add in on the felony murder pattern. Going on, assault, aggravated assault, weapon on 16. 17, firearm is a deadly weapon. Determining if weapon is offensive. False imprisonment, attempt. 18 is conjunctive, disjunctive. I need to address which counts we're referring to there. Affirmative defense definition. And that would be acts, looks like plural. Justification, grounds for arrest, right and duty to execute a citizen's arrest. Page 19. Synonymous terms, must make the arrest contemporaneously, probable cause is not enough, and then probable cause. Probable cause is a question for the jury. Page 20, may not arrest on suspicion alone, duty to inquire, arrest, right to resist unlawful arrest, illegal arrest, right to use force, and then criminal trespass. 21, duty owed to a trespasser, burglary in the first degree, intent to commit theft, burglary entry amplified, burglary intent to steal amplified. Page 22, affirmative defense, justification and use of force in defense of self or others. Page 23, to fill in the felony. As long as it's not a fire alarm or something. It's just something going on. Okay. All right. 23, reasonable beliefs explained. No duty to retreat. Justification, use of force in defense of property. 24, excessive force. Revenge. Verdict generally. 25, multiple defendants, verdict form. I think the verdict form, I need to make sure they understand that they're going to be received. Well, I'm planning on doing 3 separate verdict forms, one for each defendant. So a special verdict form for each defendant. Okay. Court has no interest. Sympathy, page 26, responsibility for sentencing, deliberations, unanimous verdict, and retire to the jury room. So that is what I have in the draft charge. Looks like I had fewer edits than I thought I needed to make. So it is apparently pretty clean the way it is. So let's go ahead and start with any objections or exceptions. I'll start with the state.
Thank you, Judge. First off, the state has no objection to the stipulations charge being read the way the court previously read that charge to the jury. So no problem with that from the state. With regard to credibility of witnesses, the state understands the consolidation, and the state thinks that this is fine. However, when we get to page 6, the top of page 6, where we're looking at in determining the credibility of witnesses and any testimony by them in court, in addition to the factors upon which I've instructed you, you may consider the following. And 1, character for untruthfulness if shown by opinion of other witnesses or reputation, or by evidence of specific instances of conduct which may relate to the witness's character for untruthfulness. Not sure we had any of that as evidence in this case.
Yeah, those 3 subsections are dependent upon the evidence. Looks like I didn't go through and edit them. Let me just take a quick look.
Would you like us to weigh in if we're able to?
Yeah, if we can agree.
Oh,
then-
yes, I think 1, 2, and 3 just did not come into evidence in this case. So I would agree with the state in removing them. So in order to do that, you would just not include the phrase, "this would include evidence of."
Well, I think it's the
Well,
whole...
it's actually the whole section.
Oh, okay.
Yeah,
All
it
right.
starts that section, normally under these circumstances, what I would do is just remove that entire section, starting with in determining the credibility, if none of those 3 factors exist.
We would agree with that. And you guys, okay if I speak? Or
Yeah, and if I don't agree,
Okay,
I agree though.
all right. Yes, we would agree with knocking all that out on the top of page 6.
I understand you're speaking for both
For the
McMichaels.
McMichaels, yes.
Mr. Goff?
We would join in that.
Okay, so we'll go ahead and remove on page 6, starting with in determining the credibility down to the prior statements heading. Okay.
And, you know, I can just say this, Ms. Donakowski, if you went back to page 5 under credibility of witnesses, for some of these little things that we may be able to agree with, one of the dots is any evidence of bias toward a party. I think it should be towards or against a party. Does the state have an issue with that?
Well, bias towards a party could be bias in favor or bias against. So if we want to change the wording, which I'm not sure we need to do, it would be any evidence of bias for or against a party.
I would prefer that, mostly because we use that sort of language in the jury instruction, in the voir dire.
I don't have any problem. I mean, it's changing the language from the charge, but based on what's being requested, I understand the issue.
We join in that.
All right, we'll go ahead and do that. All right.
So then we have on page 7, of course, we have our single witness corroboration and then accomplice corroboration. And what we have here under part, 1.31.93A, it says only give it if applicable, and I think I included it out of an abundance of caution, not knowing who was going to testify. The testimony of one accomplice may be supported by the testimony of another accomplice. Well, we didn't have that. We only had one person testify. So, and we didn't have any accomplices who were unindicted parties. So I think that comes out.
Well, that's when I went through this, I'm wondering about this, the whole accomplice language, there was no additional testimony,
From an accomplice, period.
period. I assume this is something that's going to be raised by the defense.
It is, Your Honor. We don't see evidence that is appropriate in that regard. Accomplice just seems to muddy up the water, and I can't even give an example of where it might have been arguably in our case.
I assume the state was going to withdraw it.
Right, I'm not sure it applies, and that's why I brought it up, because I'm not sure accomplice does apply, because normally it's the getaway driver who's already pled guilty, they take the stand and they're the accomplice, and we don't have that in this case, like a testifying accomplice. So the state will go ahead and withdraw it, given the facts of the case.
Yeah, just to be clear, I heard both the state's witnesses and the defense witness. I mean, I understand the party to a crime theory, but both indicated that on the day that there was no communication between Mr. Bryan, and either one of the McMichaels, or before for that matter, and we didn't get into anything after, and we only had one of them testify. So,
Correct.
yeah, under those circumstances, I'm going to remove the accomplice language that starts on the bottom of page 6. That's 13192. Takes us to the top of page 8. Yep, to the top of page 8. So we're moving all of what is now page 7. Okay?
So
Everybody-
then I think-
just want to make sure everybody follow what we've done.
Yes, I think it does go down to defendant's choice not to testify on page 8.
That is,
though.
actually, that's true. 13194 is additional accomplice language.
Correct.
Yes. So that brings us down to the bottom of page 8, which is defendant's choice not to testify. Thank you.
Right. And the state is fine with, all of the statement of the defendants, choice not to testify, all the way through page 9. And then, obviously, the Bruton charge had already been agreed to by everyone and already given. The limiting instruction was placed in out of an abundance of caution because the state was unsure of what would actually come in. Normally, this limiting instruction is there for possession of firearm by convicted felon, 404B acts, and other things along those lines. At this time, I think the only thing it may be required for is, I think the defendants had asked for flight at one point in time. I think someone had asked for flight.
I did.
Yeah, there was a request for flight.
Burglary definition.
All right, I'm trying to find. if
Well,
it-
and I'll tell you, just to clarify this and move into that, yeah, I don't intend to charge on flight. I think there's very clear instructions to the court on where it would be, if it would even be appropriate to charge on flight. But that doesn't mean that you can't argue facts that might be consistent with flight. But as far as the charge, the court does not intend to charge on flight.
And I thought I had requested it as well, and I was prepared to withdraw that. Obviously, Renner versus the state had been, they thought, impacted by the new evidence code, but as a result of Rawls in October of 2020, I don't think a charge would be appropriate, even though it is available under 1.36.10. But I disagree that we have not had a limiting instruction. The court gave one limiting instruction to the jury yesterday to disregard a question and to not allow it to be impactful to them. The question was incendiary and inappropriate, and as a part of your admonition, you also asked the jury to disregard, and I would consider that a limiting instruction.
So I understand what Ms. Hoag's saying. I'm actually talking about 1.34.00, which says sometimes evidence is admitted, for a limited purpose or against some parties and not others. Such evidence may be considered by the jury, and then it has a few reasons why it could be considered. So I'm not sure that this limiting instruction, as it is written here, is appropriate, since we're not going to charge on flight, and we didn't have any other evidence that came in under that.
Yeah, I'm open to a proposed instruction. I understand what you're saying. I haven't decided I'm going to give an instruction because I've already provided an instruction with regard to the question asked yesterday. I'm open to language. I'm not sure that I don't think that the limiting instruction charge in 134.00 applies to that particular circumstance. So I'm not going to charge this because this is limiting. This is trying to instruct them whether it's artful or not when it's done, on what evidence can be used for and what it can't be used for. So I'm not going to charge on this. If there's a proposal with regard to the question that was asked yesterday, I'm open to it without having made a decision about whether I will charge it.
Is it, however, appropriate, since you have it right under Bruton, as the dovetail into how they're to consider the statements of a defendant only against that defendant? and not anyone else. So but that's the only piece of evidence that I can remember that came in for only one use, or for a limited use.
I believe that's already in here.
Yeah,
It should be.
it's in there.
Page, do you see it?
It's on page 7,
7?
Yeah.
13193B.
Wonder if it did.
No, it's not 7, just remove 7. I thought prior statements, there's the prior statements and single witness corroboration.
Oh, I see. So on page 7, Judge, if you look, there's a sentence under statement by one defendant at joint trial, 1.31.93.
Okay.
Okay?
Joint trial, got it.
And actually, that actually probably needs to be put back in, because that, despite not being accomplice testimony per se, it does say any out-of-court statement made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made that statement, and only if you find such statement was probably voluntarily made. So that actually, I believe, does apply 1.31.93B, given we had that in this particular case.
I think that is what I was referring to. I agree. The only thing I wouldn't want, and I don't think you were asking for it, is that last line concerning accomplice. But
Yeah.
Correct.
Hold on. Bear with me then. Let me look, because I thought, because once we get into 9, okay, so it looks like the best place to put that, instead of just floating out there, and I'm going to be very clear about it, this language at the bottom of page 7 probably needs to be moved to just above the Bruton charge language on page 10.
State agrees.
that sounds good to us. as
That
well.
way, all of the statement language is in one place. Okay.
Concur.
All right. I think I heard a concur from Brian.
You did.
Okay.
But you didn't hear a concur on the flight issue.
No, I'm not there yet. Let me.
Oh.
I realize we're jumping around a little bit. I need to go back to you on that. So the 131.93 language, except for the last sentence, is going to move to above Bruton language. Okay.
All right. And then the state had requested prior difficulties between the parties. Obviously, that came in through the February 11th testimony.
Your Honor, we object to that. I don't think that's an appropriate use of the prior difficulties. The February 11th came in as a information that informed the decision-making of the defendants. I don't think there was any indication that there was a chase or an intent to arrest or detain as a result of what happened on February 11th. I think it was another attempt to do what just had happened on February 23rd. Prior difficulties, in the way that it's classically used, is quite different from this. It is hand in hand with sort of a revenge. And these witnesses said they didn't know each other. I don't know you. All I know is that you are, there was a black male who met this description that we've seen on videos, but we've never seen in person. And when I saw him on video again on February 23rd, I behaved this way. But I don't know him in any way. And let me throw this out too. My other concern about prior difficulties, I recall in at least one, maybe more, you all might recall, of the jury instruction summaries. What do you believe you know about this case? There was this one person who wrote out some pretty detailed information that they believed that that one of the McMichaels had been having that Ahmaud Arbery had been having an affair, and I'm using affair in a nicer way than what they put on the questionnaire, but had some sort of experience with the McMichael's daughter, and that these guys were seeking revenge for that experience. So the idea, that would be the classic revenge, which comes out a little later, which we oppose. I think there would have to have been proof that there was knowledge of these people, not that you are using a video to identify an individual later on.
The state's position is that evidence of prior difficulties or lack thereof, which is why I'm assuming Mr. Bryan would want this, between the defendant and the alleged victim have been omitted for the sole purpose of illustrating, if it does, the state of feeling between the defendants and the victim and the reasonableness of any alleged fears by defendants or alleged victim. So in this case, we have self-defense, which is I was put in reasonable fear of receiving serious bodily harm or death by Travis McMichael. Well, there was a prior interaction between the two of them that he described in detail on February 11th, 12 days before the homicide. The state feels that it is very relevant that the jury know that evidence or lack thereof, they can consider it for the reasonableness of his fears or the reasonable apprehension of the victim, which of course, that's part of the aggravated assault charge. And of course, there's a cautionary sentence at the end. Whether this evidence illustrates such matters is a matter solely for you, the jury, to determine, but you're not to consider such evidence for any other purpose. So while Ms. Hogue may be correct in the sense that we often have I was afraid of him because I've known him for years and he beat me up in high school and therefore that was the nature of our relationship in the past, we don't necessarily have that here. We do have 12 days prior to this homicide and interaction, and I believe on direct examination of Mr. McMichael, Mr. Sheffield had him talk about why are you breathing so hard? What's going on while you're making this 911 call? So I think that is appropriate to talk about the alleged fears of the defendants or alleged victim.
Judge, if I may add something, I kind of agree that this charge should be, and it's not the classic prior difficulties like in a domestic but if we could change one word, I think it would make sense for everybody. And instead of difficulties, which seems to imply they know each other, if we could change evidence of prior difficulties to evidence of prior interactions, a more neutral term, because they don't know each other. It's an incident that informs Travis McMichael and may inform Mr. Arbery. I think it would make more sense in this particular case.
I would suggest if we were going to do that, I have reservations about the charge, but the word instead of interaction would be encounter. I think that actually most accurately describes the state of the
I don't have
evidence.
a problem with encounter either.
Let me think it through, because Ms. Hogue, I think accurately points out, normally this charge is not, it's presented for the prior difficulties, not any indication of a lack of prior difficulties or interaction. Let me think that, I'll come back to that. Let me just think it through a little bit and see if there's some way.
And Your Honor, if this helps, I always enjoy charge conferences because I like the give and take, but I would withdraw my objection to it based on the arguments that I've heard. I do prefer changing the word difficulties because I'm not quite sure that matches in case.
Well, yeah, and that word is the word in this charge. So, and what I mean by that, not just that it sits in the pattern, but that is the defining word in the charge. I mean, it really either works that way with that idea. My concern is changing the word changes really the nature of the charge too much. That's why I'm going to think it through. I'll come back to that.
All right. So with regard to our next section, which is identification, we have two sections. We have 1.35.10, identification reliability, and then we have 1.35.11, identification burden of proof. The court obviously noted that I did not put in the reliability one, and the reason for that is this is not a case of mistaken identity. It's not a some other dude did it case. It is not a case where we have anything in dispute. Officer Minshew showed up on the scene and there's photographs of all three defendants standing there. It has not been any sort of identification issue. They were all identified by law enforcement officers who took the stand, and Travis McMichael took the stand and said, yes, that was me, that's what I did. So this charge in the state's mind is not really appropriate because it really talks about the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident. We don't really have any of that. Possibility of mistaken identity, don't have that. Was the witness's identification influenced by factors? Well, this isn't an identification case. So the state only did the burden of proof because it is the burden on the state to prove their identity, and we believe we have done that. But this charge, 1.35.10, is really in an identification case, so we didn't propose it.
Well, and 135.11, so is that being withdrawn?
Oh no, 135.11 we feel has to be charged. So it's really 10, identification reliability, that starts on the bottom of page 10 and goes to the middle of page 11, that addresses identification by some person who may know or not know that person. But we do feel 1.35.11 should be charged.
Well, if we deal first with 1.35.10, we also had sought to ask that it be excluded. It does not seem appropriate.
And I added that in because normally it comes in and the pattern 135.11 was asked for without modifications, so it wasn't terribly clear what specifically was being asked. I don't have any problem removing the identification, but if we're going to keep 135.11, it needs to be tailored, because right now, at least what I understand, let me look real quick.
Well, can I throw this out, Your Honor? I think when we originally began the case, we were not sure what the state was going to be asserting with respect to who had been on that video the 4 other nights before. The state did draw back from that, even though you did not give a stipulation that it's Ahmaud Arbery. All of it's assumed, it's implied, it's assumed, and no one disputes that that's Ahmaud Arbery in the house on those other occasions. That's why I would have wanted to have an identification charge if there had been some dispute about it. But our clients are there on the scene, having called 911, the shots fired, and there the police come, and there they are, and they say, hey, this is what we all did. These are the roles we all took. This isn't a whodunit. So for that reason, I think identification just muddies the water.
We concur.
So are you proposing
None
both
of it.
10 and 11 to be out of it?
Yeah.
The state doesn't object, we'll withdraw 11, because if it, I just put it in there out of an abundance of caution, because in similar situations as this, I've had judges not read 10 and read 11, but we can take it both out on the consent of the defense.
Okay, 11 is out then. Which gets us to fingerprints. You'll see fingerprints was requested. I tried to tailor it to the evidence in this case.
Yes, Judge, and I think I had submitted tailored instructions on certain ones of these to tailor it to the actual facts of the case.
Okay. All right, I'm sorry. Go ahead.
And I think you've got it absolutely correct. I think this may be exactly how I tailored it. The state agrees with definition of crime, intent, parties to the crime. The state agrees with having A, B, and C, as D doesn't really apply in this case and has been appropriately removed out of 1.42.10.
I'm sorry, I was one step behind you, Linda. Can you just say where you just were?
Sure. I skipped over definition of crime, intent, and no presumption of criminal intent, as they all are patterned, and the state has no problem with that. I was confirming that the state is fine with, on page 13, 1.42.10 parties to the crime, where A, B, and C are fine, and we've of course removed D as it does not apply under these circumstances. 1.421.
Before we move on 1.42.10, having read what we used to call Kurtz, I don't see how C applies. Advising, encouraging, hiring, counseling, procuring, none of that took place. There's no evidence of any of that. It's either directly commits the crime or intentionally helps in the commission of the crime.
The state respectfully disagrees. Greg McMichael ran into the house and said, "Get your gun, come on, come with me." That is encouraging someone to come along, and counseled him in the car. Cut him off, do this, do that. So we have Greg McMichael advising Travis McMichael, counseling Travis McMichael, and encouraging Travis McMichael. So we feel that C absolutely applies.
Well, it might theoretically apply to the McMichael defendants. I'm not sure I could agree to that, but it definitely doesn't apply to Mr. Bryan, and I think the court needs to tailor the charge, bearing in mind that there is case law out there that would suggest upon request of the defendants that the court would separately charge as to each one. We haven't asked for that, but I do think here, given the importance of the issue to Mr. Bryan, the court needs to limit the application of the C to the McMichael defendants only, because there's absolutely no evidence and therefore nothing for the jury to consider as to whether he advised, counseled, hired, or procured someone else to do this. That is limited if to any defendant to the McMichael defendants. We specifically object to telling a jury that suggesting to the jury there's a factual basis from which they could find that Mr. Bryan could be guilty of murder or any of these other charges under subsection C, because he can't as a matter of law.
Well, Your Honor, that's for the jury to determine. And if the law doesn't apply to those facts, the jury will find that the law doesn't apply to those facts, because what they're going to do is they're going to look at the facts and see if this applies. And that's their job. So to advise them on the law and go, well, this only applies under this circumstances, I think that might be the court commenting on the evidence, because you're saying, okay, it only applies here, it doesn't apply there. They're the finder of fact, and they'll decide which law truly applies under those facts.
That's fine, if that's really where the state wants to go. But Mr. Bryan is entitled under law for him to be charged with him. We could ask that all of the charges be tailored to him and then separately to each of the McMichael defendants. We have the right to ask for that. We're trying to be, I don't know, I don't want to say the word team player in dealing with the prosecution in a criminal case, but we're trying to work with everybody here. But it's unfair in Mr. Bryan to just throw that charge out there and let the jury think that applies to him when we know that subsection C does not and cannot under these facts.
And we would object to the court indicating that subsection C applies, if it does, only to the McMichaels. I suppose the state could come up with, they'll have to come up with some argument if they're asking for party to the crime for Mr. Bryan, and they'll be making an argument either under B or C, or A, I guess. So if they believe that they might tiptoe into C with respect to their argument as it pertains to Mr. Bryan, then we wouldn't have to worry about separating these charges out.
Well, the language, I mean, it's or language, so it's disjunctive. The court in its charge is never commenting directly to the jury on the evidence. We're simply providing the jury with the law that they then use the facts that they have determined and apply those facts to the law. Counsel will know what the law is, and if the position is there's absolutely no evidence that this is a basis for party to a crime, I'm sure that will be pointed out. I am concerned that if I start breaking this out, particularly on parties to a crime, given the importance of that legal theory in this case, that the court is going to start moving towards a line that I don't want to move to, which would be a comment on the evidence and what would be appropriate under the circumstances for each particular defendant. I understand what you're saying, how there could be separate charges, but under these circumstances, it's very clear, and I think actually the new charge makes it easier. I mean, you got A, B, and C. The argument is C simply doesn't apply to Bryan. That's an argument that can be made. I'll think it through, but I'm inclined to leave the charge the way it is.
And then principal failure to prosecute. Obviously, this is often used in a co-defendant case where only one co-defendant is here and the shooter's already been convicted and the getaway driver's on trial. The state put it in there out of an abundance of caution. I don't know if defense counsel objects to it or wants it in.
Doesn't seem to apply.
You're on principle?
Right, 1.42.11.
I don't think it applies either. The McMichaels do not.
Your Honor, the state's presented evidence, whether that was their intent or not, suggesting that other people were involved in this thing. Other witnesses, and I'm not going to name them by name, who, my understanding, had to hire counsel to defend themselves during this investigation. I think that, as I'm sitting here, and I'm subject to conferring with co-counsel, but you've had several witnesses testify and referenced in this case that arguably were a part of the same chase that the state is attributing to these defendants. I'm surprised the state wants to withdraw it, but I just asked the court, I'm going to confer with co-counsel, but I was kind of liking the charge.
The state's not withdrawing it. The state was asking if there was an objection or if the defense counsel were okay with it. And I have absolutely no idea what Mr. Goff is speaking about other people involved in this chase. So the state would like it in, but I didn't know what the defense position was on that.
Well, I'll leave it in for the time being. Mr. Goff, if we need to address it, we'll go ahead and address it.
Knowledge, obviously, should be included. Conspiracy, the state is asking for, on page 14, 2.02.1, 2.02.20, and 2.02.30. This is the law on conspiracy, and I understand that the defense is going to object to this because the evidence has been that there was no pre-planning beforehand where they sat down and had a meeting at somebody's house to determine what they were going to go ahead and do. And there's no evidence that they were in phone communication while all this was going on. However, the law is that there can be a tacit agreement. It can be a wink and a nod. There can be a, okay, you go this way, I'm going to go that way kind of thing. Because it actually says the existence of a conspiracy may be established by proof of acts and conduct as well as by proof of express agreement. The state's not contending express agreement here, but it can be established by proof of acts and conduct. And it's for the jury to consider. That's the exact line at the bottom. Whether or not a conspiracy exists in this case is a matter for you to determine. How do you determine? Presence, companionship, and conduct before and after the commission of the alleged offense may be considered by you in determining whether or not such circumstances, if any, give rise to an inference of the existence of a conspiracy. The reason this is important to the state is because of the immediate aftermath. The immediate aftermath, meaning Greg McMichael going up to his son and telling him basically what to say. You had no choice, you had no choice. Going over and talking to Mr. Bryan and then coming back going, oh, he's got video about this. Going around and speaking to a number of people on the scene, inserting himself into the corner, trying to talk to an officer to find out what was happening. This presence, companionship, conduct, immediately after the commission of the alleged offense in the state's mind allows them to determine whether or not it gives rise to an inference of the existence of a conspiracy. And that is why we are asking for all of this, because that is something we are going to argue. Greg McMichael attempting to go ahead at the scene and talk to all of these people and insert himself into that part of the investigation to get his narrative out.
Your Honor, the McMichaels object to any charges on conspiracy. Number one, it was not included in the indictment. They were not charged with conspiracy. Number two, the things that the state really is seeking in their presentation of evidence throughout this case has been party to the crime, already strongly dealt with in 1.42.10. The court well remembers that there is evidence that there had been no communication, not even the existence of the telephone numbers or Facebook connection of the McMichaels to Roddy Bryan before February 23rd. Conspiracy is not proven, even if every single thing that Ms. Dunikoski is alleging, is arguing, is proven, it still is not a conspiracy because it was not any agreement to engage in illegal behaviors. There's nothing illegal about one going up to one's son and providing comfort. There was no evidence that there was any attempt to mess with, to change, to hide, to hinder the investigation, no attempts to change the videotape. Greg McMichael at the scene, realizing that there was a videotape and the police immediately getting the videotape, means that that videotape, as their experts testified, as their GBI forensic folks said, has not been altered in any way except for the cuts that the agent himself made in order to be able to review it and manipulate it in ways of slowing it down or speeding it up. There is no evidence of conspiracy after the fact if the communication between these parties does not involve a conspiracy for a common agreement concerning an illegal act. There's no illegal act or attempt to hinder the apprehension of anyone in this case or do any damage to the evidence or obstruct in any way. Now, you had looked at some of the, did you want to jump in?
Your Honor, we likewise object. We adopt the excellent argument made by
Co-counsel. And I would point out to the court that I've been raising this issue constantly through this trial, that every day we go, the state brings us ever closer to requiring a severance to protect Mr. Bryan's rights. You know, whatever's going on between the McMichaels after the fact, there's just no evidence that Mr. Bryan has done anything after the fact that would justify this charge. And again, it's putting us in a position where the spillover from the McMichael defendants is going to deny Mr. Bryan a fair trial. Your Honor, I don't even understand conceptually how the state proceeds here. I thought, maybe I missed a day in law school, but I thought a conspiracy had like an agreement and an act in furtherance of it. What the state is doing here is conflating the two, that you don't have two separate elements, that they can say something is proof of an agreement that never existed and therefore they can get this charge. It's just not tailored to the facts of this case. It's opening up a Pandora's box, Your Honor. The jury, they're going to be having the jury sitting back there thinking that Mr. Bryan is conspiring with the McMichael defendants because there's a video that the jury's heard that he made. And then how am I supposed to be responding to that? This is it's inappropriate. It raises a whole host of inappropriate issues. It's going to force us into a posture. Of course, I'll have to confer with Mr. Bryan over the weekend about it. It's going to force us into a posture to ask for a severance.
Your Honor, I'm going to cite to Carpenter versus the state, 305, Georgia 725. This is a Georgia Supreme Court case from April of 2019. Of course, it cites to Edge versus the state. It is not error to charge on the subject of conspiracy when the evidence tends to show a conspiracy, even if conspiracy is not alleged in the indictment, which we all know. In this particular case, the Supreme Court of Georgia said, listen, the totality of the jury charge is what the juries are considered. It's not in isolation. And here they said the instruction on conspiracy, the trial court charged the jury that the prosecution had the burden to prove every material allegation of the indictment beyond a reasonable doubt. You're going to give them that. And in this case, the trial court also charged the jury in connection with its instruction on conspiracy that a conspirator is responsible for the acts of other parties to the conspiracy only insofar as those acts are naturally and necessarily done to further the conspiracy. Obviously, that is right there in the middle of 2.02.20. So that is the same charge we've got. This, in Carpenter, the state's theory of the case was everyone was a party to a crime. In that case, the party to the crime had to be, was felony murder based on a marijuana drug deal. and then the subsequent armed robbery situation that ensued. And they also then cited to Ware versus the state, another 2019 case where the jury charges as a whole adequately informed the jury that the defendant could only be found guilty of felony murder if the predicate felony was the proximate cause of the victim's death, and the charge on conspiracy was not error. And in that case, to give conspiracy along with party to the crime, that was appropriate. So we ask that you go ahead and give the conspiracy charge, as it is not error according to the Georgia Supreme Court in Carpenter versus the state.
Even if the first two portions would be relevant, Your Honor, the state is pursuing two separate conspiracy theories. They're pursuing a conspiracy theory on the chase, and now they're pursuing an after-the-fact conspiracy theory on conduct afterwards. Your Honor, I would respectfully ask, if the court doesn't strike the entire conspiracy charge, that the court specifically strike 2.02.30, because that conspiracy is not supported by the evidence. It's basically, I mean, the constitutional implications of three people who are at the scene of a death and are arguably not free to leave and compelled to remain, to be trying to use that as an after-the-fact conspiracy, that is just wrong on a lot of different levels. If the court's going to give any part of the conspiracy, at least take out 2.0230. It's one thing to say that they want to argue a conspiracy to chase Mr. Arbery, however wrong that would be under the evidence. But to come back with this second alternate conspiracy theory, independent of that, which is highly prejudicial to Mr. Bryan and not adjusted to the evidence, that's just wrong. We ask the court not to allow that portion of the conspiracy charge.
All right, let me just think it through. I'm familiar with the law and the fact that conspiracy doesn't have to be alleged in the indictment. Clearly, it was not alleged in the indictment. I still have some concerns about what is being alleged as the conspiracy versus the state's theory, as I understood it all along, on parties to a crime, which is further muddied, I think, in this case by the fact that you've got a father and son, and so the whole contact and companionship charge. Let me think it through, because again, this is one of these charges I may not permit it as a charge as far as any arguments associated with conduct. Reasonable inferences made from the evidence may be the better direction, but let me think it through. So I'll take that under advisement. That's 2.021, 2.022, and 2.023. I'll come back to that.
Thank you, Judge. Venue is pattern. Now, on offenses charged, the defendants are charged with the offenses of malice murder, felony murder 4 counts, aggravated assault 2 counts, false imprisonment, and criminal attempt to commit a felony. That seems appropriate. And then malice murder is the new jury charge, which seems appropriate. State asked for motive, top of page 16. Felony murder, and that has the right 3 charges underneath it. And I think where we have causation, which is the pattern under 2.10.30, once again,
Should be the same 3.
it should be the same 3 of aggravated assault, false imprisonment, and criminal attempt to commit false imprisonment as the 3.
It's on top of page 16.
Yeah.
We're catching up to you here.
Your Honor, with regard to motive, if we can start with that one, because I don't think there's any objection to the offenses charged per the pattern jury instructions. I am, as I sit here, I'm not aware of any evidence of motive submitted by the state, tendered into evidence in this case.
Correct, and that's why we want the charge, because it says the state does not have to prove motive to prove murder. So it prevents the defense from getting up here going, they didn't prove to you that he had a motive to do blah, 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 blah. The state doesn't know what's in the mind of Travis McMichael, Greg McMichael, or William Roddy Bryan, and we don't have to prove that they were motivated by one thing or another thing. What the state has to prove is that they committed the act. So we actually truly really want this to rebut any argument by the defense that, aha, they didn't prove motive, therefore they have not made their case, which is why this is always included. However, the state does feel that it did prove some motive, and that the state is going to make reasonable inferences about some motive evidence. And that evidence of motive is going to include Travis McMichael writing down the very first thing on his written statement is, my gun got stolen. And so motive is, I'm angry about my gun getting stolen. This guy probably stole it. And this is a reasonable inference the state is going to go ahead and draw, that he's angry about his gun being stolen. He wants to blame somebody, and this is a perfect person to go ahead and blame. So there is a reason to have this in there, especially since the state does not have to prove motive to prove murder. And we don't want the jury misguided, thinking, well, they didn't prove murder, they haven't proven motive, therefore they haven't proven murder.
Yeah, I mean, it seems to me the crime is defined as it's defined. There's a lot of things the state doesn't have to prove. Singling out what it doesn't have to prove emphasizes that. I'm not sure how the state's going to argue that the gun was the motive when the overwhelming evidence in this case is contrary to that, but that's their problem. Any evidence of motive has been admitted for your use seems to imply that evidence of motive has been submitted. Again, the state seems to be arguing both ways, that there was no evidence, they don't have to prove it, but yet there was evidence from this gun being stolen. So I would object to 2.10.12 being given in this case.
Your Honor, first, I object to the whole charge, 2.10.12, but even if you accept the state's argument about not having to prove motive, that's the first sentence. The second sentence about evidence of motive, I agree with the McMichael defense. I didn't hear it, and specifically in terms of Mr. Bryan, and again goes to whether he should have his own separate jury instruction, separate apart from the other defendants. There's no evidence of Mr. Bryan having any motive in this case. So if they want a limiting instruction based on the evidence they can articulate that I haven't heard yet on the McMichaels, that's one thing, but there's no evidence of motive with respect to Mr. Bryan. If the state has some, maybe the state would enlighten us.
The chart, it's an accurate reflection of the law. I think it covers a number of various things that the jury may be looking at. You know, one of the things about Georgia law and people's general lay understanding of the law is Georgia's position on motive. And I do think it's appropriate to charge the jury so the jury understands what Georgia law is on it. I'm going to go ahead, I'm going to go ahead and keep it, having considered the objections of counsel.
Thank you, Judge. So aggravated assault.
Can we go back to 2.10.30? The line, you're going to be including the felony of aggravated assault, false imprisonment, and criminal attempt
To commit false imprisonment.
Okay, and are you doing ands or ors?
Let's see. You may find a defendant guilty of felony murder if you believe that he caused the death of another person by committing a felony. I guess it should be just in this language, by committing a felony, semicolon, as just previously charged. Aggravated assault, false imprisonment, and criminal attempt to commit false imprisonment are felonies in the state of Georgia.
And should we just move the paragraph that you have, the second paragraph of 2.1020 down to that sentence then, so that you're not repeating it?
Yeah. And as I was writing that, I was thinking we're repeating it within a sentence of each other, so we can just look at it. Well, actually, by committing, no, I think it is a separate thought, so let me think this through. I think the language probably in the 2.10.30 should be along the lines of, you may find a defendant guilty of felony murder if you believe that he caused the death of another person by committing one of the felonies just described. That covers it, and that way I'm not repeating it.
Yes, Judge, that's fine.
Okay, so I'll drop in there. Okay.
The aggravated assault charge is acceptable to the state because it covers both instances we have here as we charged in the indictment, deadly weapon and object, device, or instrument when used offensively, such as the pickup truck. It also appropriately charges the two ways the state has let the defense know that the aggravated assault with the shotgun is to cause a violent injury to the alleged victim. The aggravated assault with the pickup trucks is to intentionally commit an act that placed the victim in reasonable fear of immediately receiving violent injury. And so the next page, topic 17, as to count 6 of the indictment, the aggravated assault was made with a deadly weapon. And that is count 6. I'm trying to do the math in my head. And as to count 6, material element of aggravated assault was made with the object, device, or instrument when used offensively.
I think you just
That is
misstated.
correct.
That's count 7.
That's count 7.
Yes.
Correct. And so the state is fine with how the aggravated assault is laid out. 2.20.22 is right out of the pattern charge. And then we have 2.20.23.1.
Which is actually the new pattern, I believe.
Right, and I failed to include it obviously because it's the new pattern.
But I do think the court added that because it's being charged both ways, so it needs to be both sets of charges.
Correct. And the state is fine with that particular pattern charge. 2.26.1 is, of course, the statute. Attempt is also 2.01.10.
Hold on. Coming back to the aggravated assault, I submitted an aggravated assault charge that was considerably different. It doesn't look like much of it survived the process so far. But, you know, we did, and I resubmitted it today, a special instruction on unanimity, an excerpt from the previously submitted one. There's nothing in here that adequately addresses the requirement for unanimous verdict in the context of the aggravated assault charges, which is why that was submitted today. Also, Your Honor, we would contend that, and we've resubmitted today, the subsection I would now refer to as last clear chance. I think that when you're talking about aggravated assault, the motor vehicle in the context of a chase, I think you need to charge a jury that in that context, you need to consider whether the defendant, whether the deceased effectively had the last clear chance to avoid contact with the vehicle. If this is in fact a citizen arrest case, if I misspoke, feel free to.
No, that's me clearing my throat.
I don't know if that was some kind of secret code, but I just want to be sure. All right.
It's an allergy code.
All right. Your Honor, in a chase case in a citizen arrest, if someone pulls their vehicle up ahead of somebody, in that context, it's different than if they're just going down the street and somebody comes out of the blue. And that, of course, gets to issues I know the court doesn't want to get into. But I think in this case, the jury needs to be charged that if Mr. Arbery could avoid contact with the vehicle, whether he's legally required to stop or legally required to step off the road, when he has the last clear chance to avoid the contact with the vehicle and he doesn't exercise it, then the defendants can't be held responsible or can't be held liable for that. I mean, I don't understand why a principle that makes perfect sense in a civil context has no application in this one. Now, if the state's theory is that, you know, that this was a revenge thing, I mean, I think there's still a charge we haven't gotten to yet about revenge. I mean, that's certainly one thing, but from Mr. Bryan's perspective, he doesn't know this person, has no relationship with him, he's not even there on February 11th. I think a jury needs to be able to consider whether Mr. Arbery reasonably thought he was in fear if he thought that Mr. Bryan was trying to attempt a citizen's arrest or assist in a citizen's arrest. That's a very different context, and with all due respect to Ms. Dunikowski, there are no prior Georgia cases, none whatsoever, that address the application of an aggravated assault with a motor vehicle in this context. The only case that's even remotely close is the one cited by this court in denying the special demur. And when you go back and look at that case more carefully, there's a lot more going on there than a motor vehicle. The person's actually struck with the motor vehicle, if I recall, flips over the front of the vehicle and ends up being stabbed or stabbing well, I can't remember, the driver stabbed him or he stabbed the driver. Clearly a very different context. And I'm asking the court give the portion that I've resubmitted today, in considering whether one or more of the defendants attempted to commit a violent injury with a pickup truck. You may also consider whether the danger associated with the operation of the pickup truck and the resulting fear, if any, was avoidable. That is to say, contingent or conditional on the voluntary actions of the deceased. If the totality of circumstances established that the deceased could reasonably have avoided the danger and attendant fear associated with an allegedly assaultive act by his own conduct, whether by stopping, slowing down, leaving the public street or highway, running to the lawn, to the neighbor's house, jumping in a pool, climbing up or beside a tree or other object. You may consider whether Mr. Arbery had the last clear chance to avoid any such danger and contributed to that danger by his own conduct. And again, that kind of gets to the heart of what this case is about. This is, as I understand, the state is contending this was an unlawful citizen's arrest. And Mr. Arbery is assumed ignorance of the law is no excuse. He's supposed to know the law just as well as everybody else who was out there that day. And to say that conduct that otherwise might be viewed as creating a fear, in that context, if Mr. Arbery could reasonably think these people were trying to stop him or detain him, pursuant to the citizen arrest statute, then yeah, he has a duty at some point to get off the road. Yeah, let them go to jail for false imprisonment if that's what's going on. But to be charging them with an aggravated assault that he could have avoided by submitting, that is not adjusted to the law. And we need some kind of charge. That's the best I've come up with. I'll defer to co-counsel if they've got a better way to handle it. But we've got to address the fact that this supposed chase with these motor vehicles is in the context of a citizen arrest. And that's very different than the context in the case that Your Honor cited in his order, which if I recall, there was I think it was a prior difficulty. It was either prior difficulty or they had no prior relation to the person had no reason to know what was going on. That's very different from this context. Mr. Arbery knew what he did that day. He knows the conduct that's reflected on the videos. And under those circumstances, I think the court has to do something more than simply charge the jury with the statute and let the jury try and sort it out. And certainly, if questions start coming back from the jury, better that we address this issue today and over the weekend than be sitting here in real time while the jurors are coming back with a question, which is reasonably foreseeable, and then we're going to have to find a way to address this issue. Or, as we apparently plan to do with so many other issues, when the jury comes back and asks a logical question about gaps in the law, we're just going to tell them that's all we can tell you. This somehow, some way, we need to be addressing that the aggravated assault statute in the pattern charge does not address the facts of this case, and it needs to be adjusted to them.
So you referred to something that was filed this morning. I don't have that. Was I provided a copy of it?
There was no courtesy copy. The original copy filed in the courtroom with the clerk this morning is what I'm referring to.
Okay, I haven't seen it. I'll go ahead and look at whatever was filed.
Thank you.
State disagrees completely, as there is no supporting case law here, and there is no duty to retreat. The victim of a crime is a victim of a crime, and to allege that the victim contributed to his own victimization by not avoiding the criminals enough, that's not the law for aggravated assault, Your Honor. So we totally disagree with what was handed to the state this morning. Defendant's request to charge, it's the first page unnumbered and the second page unnumbered on unanimity. You are going to charge the pattern on unanimous verdict, and that is sufficient.
And for the record, Your Honor, all I've done is break down paragraphs of charges already submitted to the court. There's nothing new there. These are simply broken down so that on appeal, we don't wind up in the posture, well, you know, we gave there's a 3-page instruction submitted and one portion of it isn't quite right, so we're not going to present any of it. That's why I've resubmitted the same things broken down the way they are. So there's no surprise here to the state.
Your Honor, can we have a comfort break before you go to the next?
Yeah, let me make sure we're all where I understand we are. We have just addressed these arguments on aggravated assault. It looks like we had touched on false imprisonment being the pattern and attempt being the pattern, which then got us to the top of page 18. That's where I understand we are, and that's where we'll let's go ahead and take a 15-minute recess.
Thank you, Judge.
Thank you.